Yes, yes. Good morning, everyone, and welcome, Chief Constable, to you and your team to this 2025 May public meeting. We're slightly earlier than usual to allow for those who observe the 2-minute silence at 12 midday for the 80th anniversary of Victory in Europe Day. Welcome also, Sir Ian Livingstone. You're very welcome, lead for the Operation Kenova team, who is joining us today to provide us an update with that. Thank you. Chief Constable, last month we of course published the 5-year policing plan, and it's good to see that in your accountability report to the board, the focus is being brought to delivery of the 3 key outcomes across the service and the structures that are now in place within the organisation to facilitate greater monitoring and greater reporting. Since our last meeting, there have been a wide range of complex investigations that have come to conclusion. And on behalf of this board, can I extend thanks to all the officers and all of the staff who have worked hard on those cases. Really good work and really good results. Legacy, I'm going to move on to. And today, of course, we are going to spend the first part of the meeting in public on the issue of legacy to look at some of the impacts that this has on present day resourcing of the organisation, on case handling, on civil actions, and the impact of and on victims who are seeking answers and justice, and indeed the impact of legacy on wider public perception and confidence issues in the police service of Northern Ireland. And also we will be looking at how the PSNI is working with ICRIR, as well as the implications from legislative changes being brought forward by government. With the new policing plan is published and the inquiry currently being held by the Northern Ireland Affairs Committee, it is important to understand the implications for policing and the resources required. You have publicly said, Chief Constable, that the time has come to fully ring-fence legacy funding so that current police service delivery is protected. That seems like a very sensible position that can be given support, but the challenge will be the delivery of it. So if I can hand over to you, Chief Constable, and we'll deal with the other issues within your report after the legacy presentation.
Thank you, Chair, and thank you for your remarks. So good morning to everybody, and of course everybody watching online. So I'm really pleased that we're able to make legacy the focus of today's meeting. It's vitally important as an issue for so many victims, their families, and of course our communities in Northern Ireland. And in my opinion, the legacy of our past continues to play a significant part in providing a barrier to trust and confidence in policing in Northern Ireland. Other than some marginal funding for inquests, the PSNI is not funded to address legacy. We have insufficient resources in the departments that deal with legacy that has resulted in us failing victims and communities. Those failures include slow and partial information disclosure, the inappropriate categorisation and management of sensitive information, and criminal investigations either not being completed or undertaken in a timely fashion. These observations are not in any way criticisms of the officers and staff dealing with legacy. In my view, they have done an incredible job with the resources that they have, and they continue to do their very best. But they've been let down by the absence of a plan and the lack of resourcing and funds to properly address legacy litigation, inquests and criminal investigations. Any cursory glance through the media headlines in recent weeks demonstrates the ongoing dominance of legacy and reflects that policing remains central to legacy issues. Indeed, a review of Northern Ireland and Irish media at any given time in the last 25 years will repeatedly reflect headlines of legacy stories with allegations of failed investigations, a lack of information being provided by state bodies, of vile crimes committed by terrorists, and across all victims groups of those victims being repeatedly let down. We all know legacy is an enormously difficult problem to solve. It was wickedly difficult in 1998, and it remains so today. Chris Patten never foresaw the PSNI burdening the cost of legacy, and so his commission report never addressed structuring or funding the PSNI to undertake legacy. Legacy investigations and related legal processes present immense financial, operational and reputational challenges for the PSNI. Crucially, our historical approach presents a barrier to our shared strategic determination, as set out in our policing plan, to be an organisation which is victim focused, communities focused and workforce focused. I know, because I speak to so many victims, that the attritional approach of policing and our partner security agencies to legacy issues and claims, and the glacial pace at which we have disclosed information, has been enormously frustrating to so many people, often re-traumatising victims and their families. This approach, that by and large has been the experience of too many people, has hindered the trust and confidence that we all seek with our communities. We must be more victim focused. I'm aware of and delighted by those stories where legacy matters have been resolved through inquests, civil cases or the criminal justice process. However, these cases are not sufficient in number, and all legacy bodies should be properly funded to address these cases, thereby enabling proper reconciliation and the healing of this society. We must be collectively more victim-centred in our approach. The PSNI was not designed or was never resourced to investigate, account for or make disclosure on the thousands of serious crimes which took place during the Troubles. There's never been a provision for this, and financially the burden is significant and ongoing. Without a plan and resourcing to deal with civil cases and the prospect of the reintroduction of inquests, the PSNI will have decades of these cases meandering through the courts. A consequence of this caused me to pause sensitive material research being conducted on all legacy cases other than the Omar inquiry recently. We've worked hard with stakeholders and the courts, the judiciary, to prevent that incredibly challenging decision from impacting on wider court cases. I'm hugely grateful for the support that we've received from the courts and others. In seeking solutions and taking a more pragmatic and financially efficient approach, I've instructed my team to have discussions with those legal firms representing victims to find a way through the existing delays and costly legal processes for the benefit of everyone. These meetings have begun, and I'm very encouraged by the responses. Legacy is distracting PSNI resources that should be in our communities, problem-solving local issues, tackling paramilitaries, preventing antisocial behaviour and addressing the scourge of drugs. It's taking officers from our specialist departments, tackling harmful crimes against children and vulnerable people. Those officers and staff in our legacy units are only just keeping their heads above water because of the volume of work and the demands of various legal processes. Both the drain of resources from contemporary policing and the attritional approach to legacy victims results in a significant and negative impact on the trust and confidence of our communities in the PSNI. In total, the PSNI incurred costs of £160 million on legacy matters in the last 10 years. Annually, the cost of legacy equates to approximately 400 police officers. This is a shocking figure at a time when the service faces unprecedented operational pressure. In the last 10 years, the cost of investigating legacy murders has reached £94 million. Since 2018, we've resolved 30 high-value civil cases, paying out £25 million to the applicants, including their solicitors' costs. The cost of managing this complex, time-consuming pressure to us as an organisation was £18.5 million. There are over 1,100 outstanding civil actions against the PSNI. That's up from 150 in 2014. the figure is likely to continue rising. Looking ahead, we expect the cost of our involvement in the Omar bomb inquiry to be between 12 and 15 million pounds. We're working alongside the Independent Commission for Reconciliation and Information Recovery, the ICRIR, providing them with unfettered access to material we hold. While the government have indicated they will repeal and replace the Legacy Act, we anticipate further resource will be required to fulfil requests from the Commission. Early scoping indicates these costs in the region of an extra 1.5 million a year. The major impact of Legacy is, of course, not financial. Legacy use goes to the heart of policing with the consent of our communities. Within Catholic, Nationalist and Republican areas, it's clear that the handling of legacy matters continues to harm confidence in policing. Perceptions of our role in legacy, fed by negative media coverage alongside the continuing threat from terrorism, make it harder to attract and retain Catholic officers. These issues also exist in our Loyalist, Unionist and Protestant communities. I continue to be very concerned about our recruitment from working class Protestant communities. We need to be more communities focused. We need to resolve legacy matters more effectively and be seen to be doing so. And we need our resources in communities not dealing with legacy. This is a key Pelian principle. In recent days, 3 men were seen putting up anti-PSNI posters, and at a recent board meeting we talked about the interruption of PCSP meetings by those who do not support policing. The failure to address legacy and not being seen to be doing all that we can to tackle these issues is feeding the outdated and dangerous narrative that these people use to intimidate communities. I want us to be more open and candid with victims and families, but I need the resources to do that. I also need to change some of the process by which we disclose information. I fully accept and will always comply with the PSNI's responsibility to protect sensitive information and national security. I was head of covert policing in the UK in a previous role. I know these arguments better than anyone. The current approach to disclosing sensitive information, such as redacting information on the grounds of national security and public information immunity certificates, is much stronger here than I've experienced in the UK. Those differences only serve to generate suspicion and undermine confidence in policing. These processes will improve. We've drafted a new PSNI public interest immunity policy, which we've shared with the Northern Ireland Office and the reviewer of terrorism legislation and the legislation in Northern Ireland that manages national security. That work is ongoing. For public confidence and transparency purposes, I intend to publish this policy once it's agreed. Transparency and candour are key principles of policing in Northern Ireland. All of our actions and decision making should reflect them. Regrettably, this has not always been the case in the legacy arena. This will change. I gave evidence on these challenges to the Northern Ireland Affairs Committee in London last month, together with Sir Ian Livingstone. I welcome the review being undertaken by Government of the Northern Ireland Legacy and Reconciliation Act, and the inquiry also being undertaken by the Northern Ireland Affairs Committee and examining the Government's approach to legacy. I ask that both consider the financial and resourcing implications of addressing legacy on the PSNI. I believe it is wrong to expect the Northern Ireland Block Grant provided to fund public services today to pay for the legacy of the past. These many tragic events happened under the direct rule from Westminster. This new approach is about being workforce focused, providing our officers and staff with the resources they need to police Northern Ireland properly today and address the legacy of the past. My accountability report this month makes clear the significant police work occurring across the country. It sets out significant drug seizures, successful prosecutions for serious crimes, including murders, and proactive campaigns on issues like road safety. Just imagine how much more we could do with an additional 400 officers. Since our last board meeting, we've experienced 50 petrol bombs thrown at officers on Easter Monday, and unsavoury and unacceptable violence at the football cup final, with officers being injured, and disturbances involving young people in Derry and further petrol bombs being discharged towards police. These issues are all connected to our past. We have to police a post-conflict society with the numerous challenges that come with that, such as legacy and such as other issues, as having to have close protection officers being needed to keep certain people safe. The PSNI are not funded for these issues. It's time for an honest conversation about the PSNI and how the PSNI and legacy is actually funded. We need a dedicated, properly resourced approach to legacy, which is distinct from the day-to-day work of the PSNI. In closing, when I raise legacy funding with the Secretary of State, I'm told that these are devolved matters for the Executive and the Minister of Justice. In raising legacy with the Executive and the Department of Justice, they understandably see these issues as a matter for Westminster. This needs to be sorted. This needs everybody around the table working to resolve legacy to allow this society to properly move forward. Upon the devolution of policing in 2010, I can find no agreement about funding the PSNI for the ongoing issues of legacy. Currently, the UK government focus appears to be solely on the ICRIR. That approach falls far short of the wider set of considerations that are required for legacy. If Chris Patton was to come back and review how the PSNI has progressed some 24 years after his report, I can only imagine what he might say about how this organisation has been supported. It would be very interesting to find out. Before inviting questions to my team about legacy, I very much welcome Sir Ian Livingstone and would ask him to update the board on Operation Kenova.
Thank you, Chief Constable.
Chair, members, Chief Constable, thanks very much for the invitation again to join this meeting. I want to say just a few comments, if I may, before, again, allowing the more extended conversation to take place. Operation Kenova, as you know, has been running since 2016. We are in the closing stages. I'm pleased to inform you, and I'm pleased to say that myself. We are looking to publish a closing final report, I would suggest, in the summer, certainly before we go into the autumn period. And that will summarise the work that's been carried out in terms of the depth of that work and the outcomes, but it will also highlight a number of key issues, one of them being the non-disclosure of information from key agencies. And when I was last here, I updated members on issues we'd had with MI5. MI5 have recognised that. They have done an internal review, but I will comment on the final report on the nature of the relationship with the security service and indeed other agencies when looking at legacy matters. So again, Chair, if members and the board were so minded, once Kenova is concluded and there was an opportunity, I would be more than willing to come back and speak to that at that time. However, because of this thematic focus that you have today on legacy, I was more than happy to come and join this meeting today. And I think before closing and allowing questions, I think I'd like to make a couple of really, I think, fundamental points, and I hope quite briefly. So firstly, I endorse the Chief Constable's analysis and assessment. I held the office of Chief Constable in the second largest force in the United Kingdom for over 6 years. And I also operated in an environment where there was inevitable and I suppose natural tension between devolved matters and reserved matters. Now, arguably, there was more stability within that relationship in the Scottish context, but undoubtedly there was still tensions. And I have also been in the position of looking one way, well, that matter's reserved, and then looking the other way and being told that matter's devolved. And it is deeply frustrating. But looking at the challenge round about legacy, and I had an awareness of it, a knowledge of it. I hadn't really been aware of the full impact. And truthfully, I don't think people outside Northern Ireland or people who have lived or worked within it would ever be aware of how significant it is and how vital it is to the legitimacy of public services and the legitimacy of policing. So the two key points I would like to reiterate this morning is, firstly, round about the impact of resources. Not only the resources required to address the challenges round about legacy, but the diversion of resources from the challenges of today, and just as importantly, as the Chief Constable seeks to transform and evolve the organisation for the challenges of tomorrow. We know that in terms of our technology, in terms of the ability to people to operate in the cyberspace, the PSNI needs to evolve and develop into that. And they can't do that because so many resources, and that's people. Let's talk about it. These are police officers, the Chief Constable, 400 police officers, but it's also significant amounts of money and investment are directed to that challenge. Now that's not a challenge that is unique to troubles-related matters, again, across the UK and Ireland and beyond. Legacy issues on historic child abuse, issues where children in care have been abused, does put a demand on current day resources and current day capability. But I've got to say, nothing like the impact that it has on policing in Northern Ireland and within the communities. And I think that's something that the board should be fully charged with. And I think the second point, in some ways, is even more important than that. That's really important, resources and the ability to fully fund and have the management and the leadership and the strategic discussions that are needed. But more importantly than that is to do with the legitimacy of policing. Now, the police service anywhere, but particularly, I would argue, in Northern Ireland, where the relationships with the communities are so sensitive, policing gets its legitimacy not from an act of parliament, not from a president or a king or any legal individual. It gets its legitimacy from the trust, the confidence and the knowing consent of its fellow citizens. And at the moment, that is something that the PSNI still has challenges with. And again, I hadn't realised that it was the impact of unresolved legacy matters that had such an impact on that. And as the Chief Constable's outlined, developing an organisation that fully reflects and represents the communities it serves, again, a fundamental part of legitimacy, is enormously challenging as a result of that, and gets away from what we seek to achieve, where the police are the public and the public are the police. And again, I think it's particularly acute in Northern Ireland. So I really commend the leadership of the Chief Constable and his senior team. I really commend the fact that he speaks publicly around this matter. And I say having been a senior police officer in the United Kingdom and had led a large organisation, I do think the challenges are particularly acute and particularly demanding in the context of Northern Ireland. Resources, yes, but it's public trust, it's confidence, it's legitimacy. And I think unless it's properly addressed, I think that will continue as we go forward. So again, I'm very pleased and privileged to be with you this morning.
All right, thank you for that overview thus far, and we do look forward to the final publication, and indeed we will have you back to talk to us about the report whenever it's released. Chief Constable, there are some members who have some questions on legacy issues. I'm going to open with Vice Chair Brendan Mullan, if you want to.
Thank you, Chair. Thank you, Chief Constable Sir Ian. I would like to thank you, Chief Constable, for very clearly, I think for the first time perhaps, articulating the challenges of legacy for the PSNI and the clear reputational damage that it's causing the service. You mentioned the resourcing challenges, both human and financial, and the fact that there's no budget given to the PSNI to handle the legacy cases. You also mentioned the attritional approach to legacy by the security agencies, including policing, and as I say then, the reputational damage that all of that is causing to today's police service, reducing community confidence in policing. I think the reality is that these challenges will not be addressed overnight. It's the nature of Northern Ireland. But at least I believe we have moved them up the agenda and are now clearly articulating them. I suppose there's two questions. One is, I'm trying to just understand the attritional approach. Is that driven by culture, or is that driven by a lack of resources, or is it a bit of both? And my second question then is, until such time as new structures are agreed and proper funding provided, what scope have you to implement changes to minimise the reputational damage experienced by the PSNI as a result of legacy? I was particularly interested, you mentioned you were reaching out to engage with the legal teams of families regarding a different approach, and I was wondering, can you maybe tell us a little bit more what you have in mind there?
Yeah, I'll begin with some comments, but I want to bring the team into this because this is about Team PS9 getting a new philosophy and approach to this, which is, I think, very welcome by the team. But, that'll be something hopefully to come out during this session. The first question you ask is about the attritional approach, culture, if you like, versus resourcing. I think it is a bit of both. Because we were never, ever structured or funded to deal with legacy. And in the opening remarks, I think I mentioned that in circa 2014, we had 150 civil cases, and now we've got around about 1,100. This issue is not going to go away. And if we don't come up with a plan, as best as we can with what we've got, and a plan that is victim focused and communities focused, and by the way, workforce focused, actually come up with some structures and pillars that fundamentally underpin that plan, that people can see we're doing everything we can. I think we'll continue to struggle to win the hearts and minds of certain communities. My honest belief is because of the security forces being involved in the Troubles, and I always say, having done the Kenova work, I was incredibly impressed and moved by just how well the security forces managed during the Troubles. This was a period of history that none of the countries of the world could have dealt with. It was such a wickedly difficult period of time for the security forces. But we got things wrong. On occasions, which makes my heart sink, the security forces acted criminally. They were rare occasions. But because we're on a side of this, since the Good Friday Agreement, and since we started in the foothills of looking at how we looked at legacy, because there was no plan with the Good Friday Agreement, I think the de facto position for the security forces has been one of protectionism, which I entirely understand. But as time has passed and we've matured, I think we should have changed that stance, and we should have started to reach out. And if we all, this is something I've said repeatedly, give a little, we'll probably find that we're pretty much in the same space. So I think it's predominantly cultural, but it's not been helped by the fact that there's never been a proper sit down with all of the different organisations. And by the way, the approach we seem to have taken in the past is that the lawyers for the security agencies, including the government, influence the shape of how we deal with legacy. It doesn't take rocket science to see the flaws of that approach and how that might not be welcome by people who are impacted by legacy, people who lost lives, lost limbs, lost their futures, lost their families. And I think we've got to take a far more holistic approach by all sitting around the table, rather than engagement being something that's dictated to us. So I think it's predominantly cultural, but it's clearly impacted by the fact that we've not got the money to deal with these issues. The can repeatedly gets kicked down the road, and that's got to stop. That's unacceptable. And it's having the most adverse impact on the PSNI as far as trust and confidence is concerned. The second element about new structures and what we can do, well, I'm going to bring the team in, and we have had very positive conversations with law firms who represent families, and we've got more conversations to have because there's no monopoly on good ideas on this side of the table. They will have some good ideas how to deal with these cases. But we've got to cut out, from a PSNI perspective, the bureaucracy of the legal frameworks that take years and years to resolve, which is public money. And it's public money that could be spent far more wisely in Northern Ireland on policing, on public services. So we can only do so much in that space if we are not joined by others, because so many of these cases involving legacy issues involve colleagues in the Ministry of Defence, colleagues in the intelligence agencies, colleagues in the Northern Ireland office. So, and many of those claims that we have, the 1,100 claims, there will be those colleagues I've just mentioned involved in some of those cases as well, in many of those cases. We can certainly start to resolve cases, I think, that are simply ours, where we are, if you like, the respondent, and move forward with those. But I'm calling for us all to try and get around a table, to try and come up with a plan to resolve these cases. Otherwise, and it's not an exaggeration, we will have decades more of this. Just look at the trajectory of the civil cases, and that will continue to impact on trust and confidence. And the policing board is one of your functions, as I understand it, is to help this organisation be properly funded. Well, we are not properly funded for legacy, and we don't have a collective plan for legacy. So I think this board, through this session, can help us promote the need for that and lobby for, hopefully, reaching a position where we actually get people to sit around the table. But I want to bring Anthony in and Claire around some of the things that they're looking to do to improve things for the PSNI.
Thanks, Chief. Thanks, Vice Chair, for the question. It's a really, really important question in terms of attrition, as you say. I mean, it strikes at the heart of everything we are trying to achieve in terms of being victim focused, because we realise that many of the victims are not just from today, they're from the past, and it's so important that we are here to support all victims in the best way that we can. I suppose in terms of answering your question, there are probably sort of three constituent parts that I think might be helpful. Firstly is around helping the board understand the legal architecture that has brought us to the place where we are, and that puts us in this position that we are, in some regards, attritional, and the approach that we've all collectively came to. So I'm going to ask my colleague, Lloyd McKay, who's our Head of Legal Services, to talk you through that. I'll then want to talk to you about, I think it's important for the board to understand our current structures and process, what it looks like right now within the legacy environment within policing, so you have an understanding of what it looks like. I can start to outline some plans then of what we think we need to change, and then my colleague Claire McGuigan, who's in charge of Legacy and Disclosure Branch, will elaborate on those. So if you're content, I'm going to pass to Lloyd now, back to myself, and then Claire. Thank you, Lloyd.
Thanks, Anthony. I think for me, legacy litigation is probably an unhelpful label. This is a contemporary problem. To give you some context, we have cases in court today. That's taking legal resource and legal staff away from contemporary legal issues. So the lawyers we have dealing with their legacy matters today are not advising the Chief Constable on policies and dealing with emerging risks going forward. So how have we found ourselves in that position? I apologise in advance for a history lesson effectively in this, but obviously the Good Friday Agreement, as good as it was, didn't make any statutory provision for compensation for victims of the troubles that may have sustained the worst injuries and in many cases fatalities. We then had the emergence of the Human Rights Act, and that led to significant public law challenges in Northern Ireland, holding government and their departments to account. With the emergence then of het and pony, victims of the Troubles started to receive information and properly sought legal advice to see where they could receive a civil remedy to fill that vacuum of no statutory provisions for compensation. So the lawyers in Northern Ireland played an important role at that stage in seeking justice for victims and within the administration of justice process. And they sought recourse to the courts. Unfortunately, our litigation processes in Northern Ireland aren't particularly a good fit for legacy type litigation. They're designed to deal with relatively straightforward disputes involving personal injuries or commercial disputes. Without amendments to those processes and without funding from Westminster to the judiciary and the court service, civil litigation was effectively pushed in to a bad fit of conventional litigation. And as information came out and cases were moved through the courts, one can see where the numbers increased. Obviously, we saw a rapid increase in claims as a result of the Legacy Act, because it attempted to switch off the right to bring a civil claim, which resulted in a significant acceleration and volume of claims. And as we know now, it's likely that that section of the Act is likely to be revoked, which may result in a further number of claims coming through. So we have this complex litigation claim trying to fit in with conventional models. That has led to significant periods of time elapsing. It's difficult for lawyers to advise on behalf of the PSNI because in a typical case, one gets information and one gives advice to their client so they can make an assessment of litigation risk. In these cases, it's very difficult to get the information to give that informed advice. In many cases, the information is sensitive. It's stored in various silos in various organisations. And quite simply, we don't have the resource to get the information to give proper informed advice. So within the court proceedings, we have culturally adopted the position of concede nothing. But that leads you in one direction. If you concede nothing, then the court has to determine everything. So you're effectively running every case to the absolute limit, taking up court time, which could be dealt with in contemporary court business. So as the Chief has alluded to, it requires a complete rethink. But to do that, we need resource. We need to look at getting the information at the earlier stage so that we can make an informed decision. And in those cases that should be settled, we should settle them. And those cases that should not be settled and require the court to determine the outcome, we should go to court. But we need the space to allow us to make those assessments, and we need the resource at the front end so that we can identify the information so that I can give proper advice and to my clients. And fundamentally, if that doesn't change, then the legacy journey for the claimant, who is a victim in many cases, is not victim focused. It is also not, on one view, human rights compliant for a number of reasons, but predominantly the delay. We are delaying victims receiving compensation in circumstances where the state, through the police or other parties, to a civil standard, have acted unlawfully and they have been damaged as a result. And of course, the civil courts can only provide financial compensation, and that can only go some way to putting a claimant back in the position they were in before the incident occurred. But I'm not suggesting that in any way puts them back mentally or physically in that position. But that effectively is the history or context as to how we find ourselves in a position where we have over 1,100 cases, that only tens of those cases have been resolved at this point. And it's unsurprising, I suppose, that the headlines are the costs that have been paid out. But if you have cases that some of which started in the early 2000s and have still not resolved, it's unsurprising that the legal costs are significant. That is not only on the plaintiff side, that is also the bill that is faced by the Chief Constable and that comes out of our contemporary policing budget. And on that point, the Chief has alluded to the fact there is no budget for compensation. So we have a situation where the legislation in this area sits with Westminster. Matters in respect of legacy are reserved matters, yet the PSNI are defending litigation in the devolved space in circumstances where there is no funding in the devolved space to meet the compensation that is properly due to victims and in turn the legal costs that is attracted by that process. Anthony, I think, is going to deal with our current structure.
Yeah, thanks. Thank you, Lloyd. So, I mean, in terms of the change, how are we going to change? I think it's important to contextualise how we're presently constructed, because obviously we need to understand that to understand how we may change going forward. So as it stands, Legacy and Disclosure Branch sits under ACC Justice, myself, within the PSNI. The branch itself is led by Detective Chief Superintendent Claire McGuigan, who's here with us today, and as I said, I'll pass on to. And it's got just under 200 officers and staff at present. It is 5 main units, and that in itself shows you the complexity of the area that we're working in. And I'll just give you a couple of lines in each of those areas to help you understand them. Legacy Investigation Branch is the first strand. This was formed in 2015, and that's the component part that investigates the murders that happened between 1968 and 2004. The current resourcing model of that team is approximately 60 officers and staff. So if you think about it in the current context, that would be the equivalent of 2 major investigation teams if we were looking to use those resources in a different way. In terms of cases, they have 197 cases of significant importance to their victims and their families that they're presently investigating, and they have a case sequencing model by which they work through those cases. The second strand is Legacy Support Unit, who manage our legacy inquests, and those were the ones that are included in the 5-year plan that you'll all be familiar with, established by then Lord Chief Justice Sir Declan Morgan. As it stands, we have 15 inquests presently on our books. However, it is important to highlight that if inquests were to be recommenced, as has been discussed, that would potentially add another 33, taking the total to 48. It would be our judgment, based on previous experience, that to deal with those, that would take somewhere between 5 and 10 years. The third strand is our Victims' Disability Payment Scheme. This is an important team that carries out an evidence gathering role and provides information to the Victims Payments Board. That team is made up of 20 staff who are externally funded by the Victims Payment Board. The fourth strand, and specifically in relation to your question, is the Sensitive Litigation Team. And has been mentioned here already, they're dealing with presently over 1,100 legacy cases, or legacy litigation cases, and indeed some more contemporary civil litigation. They manage the discovery and disclosure in support of those sensitive cases, and we have around 50 staff working in this area. The fifth and final strand is our Sensitive Disclosure Unit. That is 17 officers and staff covering 3 areas. We provide information to the Police Ombudsman's Office. They also manage our intelligence archive systems, and they also work towards sensitive criminal trial disclosure for contemporary cases. So as I say, in total, that's just shy of 200 people doing their very best in what is a very challenging and complex system. And I'd absolutely be delighted if board members wanted to discuss that further, or come and discuss and see the work of some of those teams. So going forward, in terms of what we can change, there are a number of factors that will influence that. Those are the decision to recommence inquests and what and when and how that might happen. The development of a case sequencing model for civil cases, and I'll touch on that in a minute. Requests for public inquiries such as OMA or any other public inquiries that may require police input, and any changes that will come out of the Legacy Act 2024 and the role of the ICRIR. But in order to reduce the attritional approach and speed up these processes conservatively, it's our estimate that we will need at least another 100 staff to be able to do that. And that only adds to the financial challenges that we are already facing. As has been mentioned by the Chief, a failure to reform does add to the barriers to our wish to serve all victims as per our policing plan. So with regards to victims, the pace at which we can deliver for them can only change with a more structured approach and better collaborative working. In terms of our communities, as someone who's new to role and having worked across Northern Ireland, I am very acutely aware that when there are issues that are relevant to the Troubles and those come out into the media, and there are conversations around delay and denial on behalf of state agencies, including policing, how that harms public confidence today and can really erode the fantastic efforts that colleagues are doing on a daily basis to try to build the confidence that we all want so determinedly across Northern Ireland. It does also have in our workforce. We have to remember that many of our workforce would not have been alive indeed when many of these cases happened, and indeed they be affected in terms of when they see their organisation being criticised. So it is important that we continue to work closely with them through staff associations and other means to encourage and show them that we are a learning organisation, and where there is learning we will take it, and that's not to criticise those that worked in very difficult circumstances of the past. So in summary, we believe that we are at a significant point in time. It's almost a watershed moment where we all collectively need to review, refine and re-energise our approach to legacy across Northern Ireland, but in policing. Specifically in request to the sensitive and the civil litigation, there are 4 really key elements that need to come together for us to achieve these. Firstly, that's an agreed case sequencing model to assist with case management, something akin to what we've seen in inquests. We've already started work on this. We have task analysts to look at our 1,100 cases to identify commonality, trends, patterns that may look and help us determine in which order we take these cases and prioritise them. Secondly, is the removal of the administrative burden of business cases and delegated authority applications. In short, if it's over £100,000, we have to seek permission from the Department of Justice, and that in itself can be a heavily burdened administrative process. We would look to see that either removed or increased significantly to allow us to make more fast-time decisions in support of victims, families and communities. Thirdly, and has been touched on significantly, is adequate resource to perform the necessary and reasonable research, and I've talked about a minimum of a further 100 people. And then finally, and fourthly, funds to make suitable offers of compensation at the earliest opportunity where it is appropriate to do so. But as has been elaborated on and commented on throughout, we cannot achieve this on our own. We need all relevant stakeholders, such as co-defendants, the judiciary, and you've specifically mentioned Vice Chair plaintiffs, legal representatives, and the Chief has talked about work that's already been ongoing, the Department of Justice and Government to make this possible. So I'm going to pass to Claire now, who can just touch on some of the collaborative efforts that have been taking place over the last few months to try to drive this forward. Thank you.
Yeah, so I think most of the points have already been covered, but just to focus in on a couple of things, and also the question that you put to us around, the culture and, what new structures that we can put in place. There's no doubt that culture will affect how we've been addressing a lot of this. But the Chief Constable has outlined very clearly what he expects of us, and so culture can always change and we can always drive that through, and that's exactly what we are going to be doing. And everybody within my team is bought into that and wants to deliver that. So I think that's an important starting point. But we're not going to be able to do this on our own. And I think it's important as well to reflect on what Lloyd talked around the void for so many years around legacy, and the fact that the justice system and the justice organisations have been left to deal with this issue. And we have dealt with a number of those issues, and we actually understand it really, really well. The judiciary know what the problems are. We know what the problems are. And now what we're looking to do is move forward with working with the plaintiff solicitors, which the Chief Constable has also mentioned there, to understand from their perspective what it is that the plaintiffs are looking for, so that we can come to those solutions at a much, much earlier stage. Because there's no doubt that when you look at how complex and laborious the legal processes are, nobody is winning out of this. Policing is not, the victims are not, the judiciary are bogged down in the courts in that way, and it would be interesting to see how much more they could dedicate their time in contemporary space if we weren't bogging them down in the litigation space. So I think that we all have to come together. The sequencing model is crucial to that, but it's getting that agreement around the table. Everybody needs to agree on a way forward. The current position is broken. It's not working. It can't work. We can't service it. We can't deliver. And I think that's appreciated and accepted by the judiciary. I think now the plaintiff solicitors are also starting to realise that as well. But I think if there's a collective effort, and we're not going to get that though without the executive and the government coming together and giving us the resourcing and the funding to do this. And I genuinely believe that we could move Northern Ireland forward in this space, but we need that effort from everybody to put their effort in to helping us do that. And I think we can achieve that, and I think this Chief Constable has made it very clear what he expects of us, and I think we can do it.
Thank you for those responses and a really, really good insight into the difficulties, the frustrations. I feel frustration. I share that frustration. And it's not just in resourcing, it's the effects that it's having on victims and families, as you quite rightly say, Claire. I'm going to just, before I move to the next question, Anthony, you mentioned 100 staff would be required additionally to try and move issues along. Can you give us an idea, if you have, of the costs of that and what level of staff and what grade that you think is needed to carry that on?
I'll ask Mark to cover the cost because he'd be more accurate than me, but certainly it was across all of the areas. So for example, if the Legacy Act is as it's currently constituted, and even if there are some changes to it, but it still requires police, the PSNI to service that, that will require staff to provide and check the information on behalf of the ICRIR as the legislation is presently written. So our estimate is in and around 25 staff for that. That will be varying grades. We have done out a sort of a table of it, Chair. I don't have it with me today. I'm happy to share it with you. But I suppose probably in summary then that might be the best way to deal with it, because I just don't have it off the top of my head. But we costed it. Mark has the details, but it is in around 100 people across all areas. So it'll be to service the ICRIR. It will be for an uplift in litigation, and it will also require resources specifically for the current public inquiry. And we also have, and that doesn't consider the fact that there may be additional public inquiries, so hence why I've said conservatively 100.
Okay, thank you.
Thank you, Chair. Yes, so maybe just to clarify, certainly the cost of legacy per annum are in around 20 million, and we've already said that would really represents a cost of around 400 extra officers, and the ask for an additional 100 officers or staff in the area of legacy would, cost in around £5 million per annum. So that's how the two figures sort of speak to each other.
Okay, thank you. And maybe if you can send us the details of that. Thank you. I'm going to move to a question from Jerry Kelly on legacy.
Thank you. And it's more comment if you've given me than questions, because I think it's have comprehensively answered the questions. And a lot of it, just let me say that I'm in the same mental attitude as yourself, Chief Constable. There's some that I'll disagree with. Just let me welcome the fact that I think some of the quotes there which I took was that this is new philosophy of approach, and it seems to be, and if it is good, and that it's a watershed moment, and that is what is needed as well. I want to welcome that it's victim focus. I want to welcome talking to legal representatives, because the families are, as you've pointed out yourself, in a very difficult place. And bearing in mind, as you've also pointed out, some of this is 50 years. There's people, Mrs. Brown in particular, which you can see on the television and that. And the issue around the British Secretary of State sending this up to the executive, and nobody has spoken without mentioning resource, and we understand that, and I haven't had a discussion with any police officer at any level, because you're telling them all to mention it. So fair play, and of course it's true. I'm not disagreeing with it. There's a huge issue if this is to be sorted, that has been. But just let me say a couple of things, and I'll be brief. Part of the problem is historical, but it's historical right up till now. And in fairness to yourself, and I've sat in front of many chief constables, you're the first chief constable who has said, we need to change this in a radical way. I know that you've been making issues both publicly and privately on PIIs, but just to give what I thought was the terrible example of how badly it was abused was around young Noah Donoghue's case, where PIIs were introduced, nothing to do with the conflict, nothing to do with what was going on in terms of politics, but that they were introduced there. And I'm glad that you're going to publish, as you have said, a PII documents. A lot of people will be waiting strongly for that. The fact is, and I'm not saying this in any sort of way of protection of that, the type of money that's involved here, and money goes into resources, so I'm just putting it in the financial way, is huge. And there's no executive that would be able to do that. I mean, that's just the fact of it. And for the British Secretary of State to say that this is an issue, it's a devolved issue, is complete nonsense, and he knows it. And they need to realise that and do something about it. And just to say this, although you may think it's past it, but you see, we keep the ICRIR, which you will also know publicly, because public is the vast majority of victims do not see it as the way forward. And certainly I do not, from a practical point of view, see it. I was involved in a number of negotiations from Haas right through. And there was and nothing is perfect. There's no silver bullet here. Everything's complex and all of that. But if you were to look at where it got the closest, where it could have made the difference, it was in the Stormed House Agreement. And ironically, going to Claire when she was talking about, we need partnership and agreement. We had all the parties, I suppose a record I have to say, except for the Ulster Unionists, which are always sitting on the fence, and the two governments had agreed to the Stormed House Agreement. And let's also be honest, what happened is one of the main players, the British government, pulled out of it. And even when they went back to it in the new decade, new approach, and said, we need to go back to the Stormed House Agreement, and we need to give them money, and we need to act it in 100 days. It's just nonsense. So that's where all the thing to the families and everybody out there looking at it. And I also agree that it is huge damage to contemporary placement. Massive. And every time you take a step forward, then you're dealing with issues like that. So, and I also have to say that during that period, I think it's been touched on by a number of speakers and acceptance of it, that while I don't blame people on the ground and people who are sitting in offices and doing investigations and all of that there, the problem was at the top, both politically and within the police. And it was glacial, I think the term was used anyway. Glacial disclosure, it doesn't even describe it. And to the point where the every now and again, when something was coming to, especially an investigation come to an end, all of a sudden there was another folder, 10 folders of files, which hadn't been seen before, was produced, and that put it back another number of years. And you see, after 10 years, 20, 30 years, what people go is that's deliberate. That's the problem, the thing that's deliberate. Now, having said the negative, if you like, or just let me say this, that a lot of people, I can't quantify it, but certainly within the victims community, and I admit that most of my contact would be within the nationalist victims community, and it is the victims community which is throughout the society, are now looking to the courts as the only place that they will get it, which now that is mushrooming into a problem as well. So having said all of that, I hope we can see a difference, and I hope we can see it quickly. But I have to say that the ICRIR, the way it is constituted, is not going to do this job, and the families know it. And it's as straightforward as that. Will some families go to it as they did to the HET, because the HET was another one in fairness to it, when it was produced, it was not said it was Article 2 compliant, but it gave certain information to people, and then that became a problem. So I don't want to finish on a negative. I really don't. But I just agree that there are issues here for the board as a collective. There's issues around financial resource, which is crucial to whatever we can do. But I repeat this. People keep looking for, politicians all the rest keep looking for something which will work. We had it. We had it. And there was no will from the British government at the time and to see that through. So I'm sorry there's no question, but I mean, you have answered a lot of questions in the middle of it, but I just think it was very important. And the Sean Brown case is a perfect example of this, still at this length of time after a very difficult conflict, that there is, and especially within intelligence agencies, not to give information. But thank you for that.
Okay, Trevor?
Chair, I feel I have to respond. I mean, like everyone in this room, we understand the difficulties and sensitivities around this. But following Jerry's comments, my community feel that they're let down, particularly by Sinn Féin and others who are the biggest cause of victims in Northern Ireland. And it seems ironic, listening to Jerry speak at the minute, that there's no reflection on what part Sinn Féin and the IRA played during the Troubles. I know this is not a stormont, it's not a political debating chamber, but I think it has to be said that if everyone wants to be honest, then everybody should be honest, and we should all come to the table honest in terms of the parts that they played during the Troubles, as opposed to working on the small numbers that the security forces was involved in. I think that's one Jerry's pointed comments around. So I certainly want to put on record our party's concerns around the process, sympathies with the police and how they deal with it. But there's a section of the community will never be satisfied unless the victim makers stand in the courts and actually own up to their part as well.
Okay, thank you. I'm going to move to the next question from Mark.
Thank you, Chair. Some of us do have questions to ask and limited time in which to ask them. This is maybe for you, well, definitely for you. Sir Ian, you've expressed frustration today, and you expressed frustration at the Northern Ireland Affairs Committee last month. I suppose that draft family reports that have been passed to the British government last August or September for security checking hadn't been released yet. You said then you hoped that would be done in the next couple of weeks. Has it been done yet? And if not, when does it have to happen by for you to meet, I suppose, your aim or hope of publishing the full report by summer, autumn?
Thanks for that question, and I'll give a very specific response to that. I actually received a letter on Friday of last week from the Cabinet Office, a very senior official in the Cabinet Office on behalf of the UK government, saying that they were now satisfied with the family reports. I had originally meant to have been in London this week with the members of the Kenova team, just to finalise them and get them delivered to families. So they are now complete. They have been subject to security checking, and in the next number of weeks, families will receive those specific family reports. I should reiterate that, of course, members of the team, the investigators, have already met personally and verbally shared some detail, but we felt, the Chief Constable felt when he was in my role, that it was very important that individual families got those reports, and there will now be 26 that will be delivered. And the final point I would say is that I think that's something that is almost unique about Kenova in its approach. Right from the outset, John had resolved that he would speak publicly on these matters, that matters wouldn't be suppressed or wouldn't be held back. And of course, the challenge of that is always round about the matters on security, because in the past, a number of reports and investigations material was not into the public domain on security grounds. So we've worked very hard under the approach that Chief Constable Boucher established to make sure that we could get as much to share with victims and families, firstly, but also the wider public interest about what happened. So the family reports have now been cleared, and we've got a short number of days' work to do before we can start to deliver them. So thank you for the question.
No, well, it's good to hear some progress in that regard. And then in relation to the decision of the PPS to prosecute no one for anything, despite the strong and compelling evidence submitted by Operation Kenova, is it your view and the view of your lawyers, I suppose, that there were cases that should have been tested before the courts?
I think back in March of last year, the interim report, the Kenova interim report that John authored, when that was launched, we had a press conference at that time. And again, in all candour and openness, we expressed a view that we thought there was a strong case. We said that while recognising entirely the utter independence of the DPP to take those decisions, and that level of discretion in terms of assessing public interest or assessing the relevancy or adequacy of evidence was a matter for the DPP and the DPP alone. But again, public justice is really important round about public confidence as well. And from Kenova's perspective, we thought a number of those cases could have been presented in court, but the ultimate decision wasn't for us. And again, that's something that we accept and recognise as well.
Could have and should have, but thank you.
I'm going to move to Frank for a question. Yep.
Sorry, thanks, Chairman. We've heard quite a range from quite a lot of people here on the scale of this problem that's faced under legacy. I think the enormity of it's probably taken a lot of people by surprise in here as well. I suppose my question is in two things. Has it been considered a totally standalone unit to deal with legacy, even independent of the PSNI, but obviously with the PSNI having a big role in it? And in an ideal world, what would be the glide path to getting this back to zero, to be able to get those officers, the 400 people involved in this, back doing what they should be doing?
So I think the standalone unit, which would have been the Historical Investigations Unit, was probably the Stormont House Agreement that would have dealt with this. I remember well the agreements around that, and then even a consultation, which was about 2017, 2018. There were 17,000 respondents. There was draft legislation. This was where you had a separate proposition of an independent commission for information recovery and a historical investigations unit. And you had broad agreements about how the director and the people responsible for those units would be appointed. You had clarity about how people could provide information to the Information Retrieval Commission in a similar way to the Independent Commission for the Location of Victims' Remains. That was stepped away from. There was a command paper in July 2021, which I'd invite anybody to read. It basically said to victims, you're not going to get an inquest, you're not going to get a civil case, you're not going to get criminal prosecution. I've never seen the like of it in my policing career. And that's why victims felt let down. They were given something that seemed to be broadly acceptable to people, political parties, to governments. And then as soon as there is progress, there seems to be something that causes that to be interrupted. And then unilaterally, with that command paper, that was the UK government stepping away from that process. And even with the comments of the Prime Minister in January or February last year, which were at Queen's University, when he said that he would repeal and replace the bill, I think victims, again, psychologically, are in this unimaginably difficult journey when, are we going to get something that's going to be meaningful? And we are still waiting, with courts testing the legacy legislation through the Dillon judgment, through Justice Colton, and it's a judgment I'd recommend you all read. I read all this stuff incessantly. In my view, Frank, the opportunity to address legacy is now. I think the Irish and British governments seem to be speaking warmly towards each other. I am neutral on this. I've listened to, obviously, what Trevor and Jerry have said, this is bigger than individual parties. This is about the people that you all represent. You know, and I have understanding for both arguments, but what I genuinely believe in, that so many innocent victims who have struggled to have a voice have actually been silenced by the establishment, and the organisations who are there to actually support them and give them information. That's why we joined the police, to help people. We've not done that, and that's probably because of something of the words that we've heard between Jerry and Trevor. We've got to get past that, and this board has got to lobby for legacy for this organisation to be properly structured and funded, because otherwise the policing issues that you, however long members of this board have been on this board, have been here for, you will have heard consistently issues that go back to legacy and the trust and confidence of this organisation. We have questions at every board. It's a cross-cutting theme, and when occasionally, a very senior politician said to me, people have moved on from legacy now, John, you need to draw a line. Just look in the media. Just look at what's happening in society and the people that we're leaving behind on all communities. So, put simply, Frank, there was a model. I think the principles of the Stormont House Agreement is something the PM did say he would be seeking to introduce in how the government deal with legacy. But it needs to be both governments. It needs to be the executive, First and Deputy First Minister. It needs to be the Justice Minister. It needs to be all parties. It needs to be a cohesive approach, and it needs to include not just the Independent Commission, the ICRIR, it needs to include the other constituent parts of legacy, which include the PSNI probably as the principal organisation in legacy. But there are other organisations as well that have similar challenges because they're not funded to deal with the public services that are required in a post-conflict society. But the template was there, and for all sorts of different reasons, it got lost. And I'm hoping people are currently having conversations that might get us somewhere back there. Okay.
Sir Ian, you wanted to come in?
Just briefly, because I think the relevance of the question and the response from the Chief Constable are crucially important. I reread the Stormont House Agreement last night as preparation for coming and reflecting on it, and I was struck. Now, it may have been unrealistic, but I was struck that when they talked about the establishment of the HIU, the Historical Inquiries Unit, its ambition was to have its work concluded within 5 years, which would have been 5 years ago, as 14, 15, round about the Stormont House Agreement. So back then, it was looking to have this matter resolved, and yet here we are 10 years later, because the HIU or something of its nature wasn't adopted, it hasn't been addressed. But I was really struck last night, and again with slightly independent eye, and just listening to that question and John's response, I said it was actually the intention then was to have this addressed, because then they knew how important it was, and yet 10 years later, we're having this debate about the complexity of the issues. I don't know the reasons behind the politics about why it wasn't there, but reading it, the HIU was well thought through, and actually had it been implemented, we may well have made progress from what we now face.
Thank you for that. I think part of the reason was also the executive was down for quite a lot of that period as well. I'm going to move to Nuala for a question on legacy.
Thank you, Chair, and thank you for your comments. Chief, I absolutely agree with everything that you have just said there in your previous answer. I think it's really sad that all of these victims are looking for truth and justice, and a lot of them just might not ever get that. And it's important that no matter what section of the community that they come from, that their human rights are upheld, and I think that's really important here, in particular in Northern Ireland. There are a couple of questions that I have. One was on one of the issues that you raised earlier, Lloyd, on the earlier conceding, that you used the words, concede nothing, nothing's conceded, and you went on to say how it is about information and resource to access that information. However, I just wanted to ask if you can elaborate. Is it because you're not getting disclosure? Is it because you can't get information? Are there cases that can be settled earlier? Is that something that is being explored internally? Because it's a conversation that we have at Resources whenever it's not legacy cases, when it's other cases, but is it just hinging on information?
Thanks for the question, Noah. I think Claire describes legacy litigation as a wicked problem, and I agree with that. The difficulty is the nature of the information you're dealing with. It's historical, it's difficult to extract from the organisation, and in many cases it's sensitive and shared with other defendants. The ownership's not always obvious. The traditional model for litigation is an action is brought, the lawyer seeks the information from the client, and the lawyer gives advice to the client so they can make an informed decision. In this situation in legacy, there's such a volume and complexity of information that basic process that would be recognised by most lawyers is difficult to achieve. So we may need to change our approach and concentrate on getting that information that allows us to make an earlier decision on litigation risk. That won't meet the test of providing all the information that the plaintiff might not or might want. But as I said before, civil litigation is an ineffective method of securing truth and reconciliation. It's not designed for that. So the lessons going forward for us and the rethink is try and get as close as you can to a contemporary model, try and get the information so that those cases that can be settled, you can have discussions about that. You can look at mediation, you can look at judge-led mediation. So other alternatives to running a case in one direction that's going to end up in closed material proceedings and a full hearing, taking up court time and adding significantly to your legal costs. So that's the aspiration for us, to try and get to the more conventional model, but it's complicated by legacy.
But it hasn't been explored yet to do that?
There have been cases that have been mediated, tend to be the high profile ones that have been pushed to the top. But because you're dealing with sheer volume, that's where Anthony was talking about the case sequencing model. And that is crucial, where we'll work with plaintiff solicitors, the judiciary and other stakeholders to try and get to an agreed route to get to those cases early.
But if you don't, and notwithstanding the resourcing issue, because I respect that there is one, but something has to move. So there should be, from my point of view, there should be some form of model before you achieve the same as the legacy, our legacy support element of the branch. I think you said uses the case sequencing. So surely it makes sense to give victims an option earlier if that's something that they want to do, particularly when we're talking about people who are coming to the end, like nearing the end of their life as well. So you're saying it's aspirational, but is the PSNI looking or exploring that now, or is it waiting out for more resource?
No, we've had meetings already with plaintiff firms and we've already had discussions with the judiciary as to try and achieve a better case management plan going forward. An aspiration is that we get it all right across the board, but we are achieving parts on that journey already. We are proactively reaching out to plaintiffs' firms to discuss, such as the point you make, some plaintiffs are running out of time, sadly. So there's a perfect example, if you were doing a case sequencing model, that you might draw those cases out and prioritise them, where sadly people might not get the opportunity to get an outcome.
And why can't you use the same case sequencing model in two separate sections of the branch? Why can't you use the same one if it works in one? I understand they're all complex, but does it have to be so different? Just talk me through that.
Yeah, I suppose the other part of civil litigation is that some of it's driven in the courts. So it would be very hard for us to put the foot in the ball and say, we're going to design something here because these cases are up today, tomorrow, next week. So some of it is driven by what's actually happening in the courts, and the questions then that I'm looking at whenever I'm trying to give instructions is, was this the right course of action? Should we be going down this road in the first place? What do we know? What more do we need to know before we could see whether there's a liability there that we should be looking to settle? And all of this becomes more difficult because we're not necessarily the only defendant within that case. But that will not be a barrier to the PSNI. We will find our own way through it if we have to, because this is vital. We have to move this on for our organisation and for society in Northern Ireland. So it is a little bit, it would be nice to have the agreed position. That's not to say that today, tomorrow and next week we will not be actively looking to see what we can do in this space before we get resource, because I think it would be naive of us to wait for that.
Intention be for all 1,100 of those cases rather than just the ones that are coming up to court? Will the intention be it's for to have a model that works, that prioritises all of the cases?
I think it has to be, and at this point in time, it really is only the PSNI that's sitting down trying to think of how we would do this. However, we are bringing people in and getting those suggestions. That's the collaborative piece that we're looking to engage with others to see what other things we should be considering. So we are trying to take the proactive approach. But as I say, we won't solve the whole problem without everybody around the table.
Can I just come in there on that? Sorry to interrupt. So the case sequencing model, which has been through court for the Legacy Investigation Branch, doesn't have, and I would have concerns about some of that. It's time-based or almost predominantly. So you need to take into account other things. We talked about the Sean Brown case, about the age of people, how much time they've got left to get the information that they deserve. What I can tell you is, of course, with a lot of the other agencies, they're not in the same position as the PSNI in communities every day trying to help secure confidence, trust, divert people away from criminal pathways. So we have far more skin in the game and need to invest in this than I think some of the other agencies who do use it almost as a process map. And we're trying to stop the process map. So what I've said to the team is we will engage with all these lawyers. Tell us those cases that you think on a human level we need to look at as a priority. Tell us what you think we could do to sequence these better. What criteria would you use? So we're doing the structure bit with them. So let's come to an agreement between the different legal firms and ourselves. But we're doing the personal bit. So tell us which cases we really need to focus on, because we might not know those individual vulnerabilities of your client. And there is something to mention. A lot of those cases will be without merit, that we will strike, we will not pay, and they'll be struck out because there is no merit to them. But there is merit to a number of cases, and we know those broadly. We would soon understand that there's merit to those cases, and that's why we've got to change this. We've got to bring a human approach to it. That's what we're trying to do.
I think that's quite helpful, just to know the mechanisms and any idea or progress for change. So hopefully everyone else can come on board. I just have a final question regarding the Hillsborough law that should be introduced by the UK government, and a lot of the talk that went public before Easter, and the reason why it was pulled was around the issue of disclosure, candour, party of arms, etc. And some of that is also relevant to Northern Ireland context and legacy. So I just wonder, from your perspective, Chief, whether you have engaged with Chief Constables of other forces or the UK government regarding the Hillsborough law and impact in Northern Ireland in particular, any impact on legacy?
So yes, I have Bishop Jones, who chaired the Hillsborough panel. I went to meet him when I first did Kenova to talk about lessons learned from Hillsborough. And that candour, that duty of candour, the approach to have a human rights focused approach to victims and the inquiry is something that I then picked up on Kenova. And at Chiefs Council, when the duty of candour was first socialised, a number of forces were concerned about it for legal reasons, because their lawyers were telling them that this caused a conflict and it was difficult. Lawyers are not bad people. There may be some in the room. They're very good people. There's one particular that's difficult behind me. Lawyers give advice. We need to understand the risks of taking a particular course of action. but the decisions should be with the people leading the organisations. In the legacy space, the people who have driven the current model, the current culture, the current structure are lawyers for the security forces. So they're inevitably defensive and protective, and I understand that. And I've made very clear my view of how well the security forces operated during the Troubles. Unfortunately, at times we let ourselves down, but that was very rare. But since the Troubles, I think during the Troubles, security forces did an incredibly difficult job really well. Since the Troubles, we have created, whether it's a deliberate strategy or not, a position where families believe everything is collusion because we don't speak to them, because we give them letters that decline them information. And that is honestly not the case. In Operation Kenova, I met so many families where I could set out what the security force has done in their cases, but they never knew. They never knew that people were arrested. They never knew all the work that was done because no one went to speak to them. And a lot of that subsequently has been driven by lawyers. So when I got this job, I was advised not to meet certain people who would be, and we've had discussions on this, Nuala, who would be victims of crime because of ongoing proceedings. I will always meet them. And I'm still able to talk to them without compromising any legal position and listen to what they've got to say. So we get legal advice, but I think in this space, it's been the dominant partner with regards to how legacy is conducted. And I think the dominant partner should be the victims from all the different constituencies, including police officers, military, nationalists, unionists. We need to take a far more holistic approach to it.
The Hillsborough law, because it would include all public services across the UK. So from your perspective?
I'm a strong supporter of the duty of candour, and Bobby's doing some work on it at the moment. I don't know if I can bring Bobby in, but I'm a strong advocate for it, Nuala. I was at Chiefs Council. I didn't understand the sentiment being given to me that we shouldn't support it, and I remain of that position.
So PSNI, as part of the National Police Chiefs Council, have signed up to a national charter around a range of commitments to the victims who are affected by public tragedy, and we've interpreted that in its widest sense. So you'll be aware that there is also a piece of work being taken forward in terms of the revised Policing Code of Ethics, which will explicitly kind of write this into the fabric of policing. And our hope would be that going forward that will help inform virtually every decision that we take, with the only caveat being that you should approach any situation, any legal proceeding with that duty of candour. The only caveat being that if you were to disclose something that you would incur another potential criminal offence, that's the only kind of line that we put against that. And again, it fits very much with everything we're trying to do in the legacy space and more broadly. And to answer your question as well, we have had contact from South Wales Police, who are working with the devolved institutions in Wales around introducing this across the structures there. And as I understand it at the minute, I think that this sits primarily with the Department of Health in our own executive, but that's something we could check out. Is it finance? Is your finance you're indicating? Yeah. So it's something that we'll pick up with them, but rather than waiting for that to come along, we are firmly committed to that as a principle.
Thank you. I'm going to move to the last question from Les Allamby.
Thank you, Chair. I want to come back to the issue of disclosure, and it's a couple of practical questions. Exclusion from disclosure on national security grounds should be proportionately applied and not used as a blanket to smother information to families. So I particularly welcome the proposals to develop a new policy on public interest immunity certificates and redaction. I wonder first if you could say when you hope to be able to publish that, recognise that you've got to go through a series of kind of processes. And my second question, which is both to you and perhaps also to Sir Ian, is the Legacy Act as it stands, and obviously the government intends to rewrite this. Can you say whether the current provisions on disclosure are helpful or a hindrance and may need to be looked at again in revised legislation? And perhaps, Sir Ian, if you could say from your Kenova experience where you think the issues are around the current provision on disclosure of information to families.
So with regards to the PII policy, we've shared it with the stakeholders I mentioned, a review of terrorist legislation, the national security legislation here, to two separate individuals, and also with the NIO. The NIO are now ready to talk to us about the document. Just to reassure you and everybody, the document's been written with the intention of being very forward-facing towards reassuring the agencies who manage national security. It sets out almost a process map of the considerations that we should make, because we seem to have been doing PII in a couple of different ways in the PSNI. So it sets out consistency. I haven't got a time frame, but my intention, I've always mentioned it to the board and deputy chair of the board, that I would share it with the board and other stakeholders, and then it would be published on the PSNI website. Okay. And I'm hoping to do that as soon as possible, but I need to do it in partnership with people who I'm trying to take into a new space, basically, around information provision. To give Ian a bit more thinking time, with regards to the existing drafting of the legislation around information disclosure, it appears to me a lot of the work that we managed to achieve on Operation Kenova in getting information through being pretty uncompromising, it feels that the legislation has taken us backwards. There are things that have been put into that legislation that would enable agencies to delay the process of getting information. So by way of example, an Operation Kenova, criminal investigation, lawfully commissioned, we would go and we have legislation supporters to get information from wherever it might be to assist us with that inquiry. Because of the very sensitive nature of Operation Kenova, we built in our structures a state security so that we can handle information of the very highest nature, and we vetted everybody to the very highest level. So there'd be no reason why we couldn't take information. In the new legislation, there is a requirement, and I know this has been looked at and I've made representations to the Secretary of State and to the Northern Ireland Office, around us providing an assessment to each piece of paper that we give to the ICRIR. There is no need for that. We're giving them unfettered access. The approach, I think, has been introduced by lawyers to provide a new layer of lawyers being able to assess every document that's going to the investigation team. The relevance also test should be with the investigation team. The way the legislation has been drafted, there is a relevancy test for the organisation that owns that material. There is also a veto in place for the Secretary of State around what would be put in reports. That veto did not exist in Operation Kenova. I don't know how things would have played out if the Operation Kenova interim report that we released on the 8th of March last year had been subject to the requirements of the bill as it's currently drafted, but I suspect we would have come up against some challenges that I would have tried to challenge in the courts. And I'm sure there's always an opportunity to challenge it in the courts, but the veto is treating that investigation and that process differently. And when you do something that's different, people start to ask, why is this different from what would ordinarily occur in an abuse inquiry in England or Wales? Why have we introduced another hurdle? What is that about? And that's the protectionist cultural approach. The Independent Commission, chaired by an ex-Lord Chief Justice, or led by an ex-Lord Chief Justice, can be trusted, I'm sure, to manage the sensitivities of that material. And there's a simple principle in anything that you're going to use in material you seize that is sensitive or protectively marked. You go back to the host organisation to explain that you want to use it for a prosecution file, or you want to use it to refer in a public-facing report, and you seek permission to do that. And you negotiate how that process would occur. And those principles seem to be absent from the drafting of the bill. And that's why I say that the ICRIR, as much as I want it to succeed, and I'm a great supporter of Declan Morgan, is not Operation Kenova, because the legal framework that has created it is different from how we operated in Operation Kenova.
Thanks for the question. And I mean, John's analysis, I think captures it. I mean, I would say, specifically on your question, the disclosure provisions within the new legislation is overly restrictive, both on the relevancy issue, the ministerial veto that John outlined, and again, the actions of Kenova show that it can be done, where you've got independent embeds within these organisations who make that assessment, who are fully vetoed. You're not relying on the organisation giving you what they want to give you. And I do think Kenova has almost, through its diligence, through John's leadership, through the rigour that's been applied, has almost opened up an area that had previously been closed. And some of the disclosure provisions, when one reads them, they appear as if it's looking to try and close them down again. And the final point I would say, and it relates to issues within the recommendations that John made in his March report, the issues that I'm going to highlight in our final report is, none of us, me, John, none of us are constitutional vandals. We recognise the critical nature of national security. We recognise the value of doctrines such as NCND. We are products of that. We've worked and used those provisions over the years. I think our position would be that it needs to be applied in a less blanket manner and a less defensive manner. And in its application, it needs to have greater recourse to the rights and interests of victims and families. And I think that's what John's legacy through to Kenova will be. And the current legislation, I think, is far more restrictive than the approach that Kenova was able to adopt.
Thanks, both of you. As one of the lawyers around the table, I can certainly say that the current Legacy Act and the disclosure arrangements are not fit for purpose in terms of what this government says it wants to achieve through the legacy provisions. And that's one issue that really needs to be addressed. So thank you.
Thank you, and that concludes the questions from members on the issues of legacy. Chief Constable, thank you to you and Sir Ian for that comprehensive presentation, and indeed to Detective Chief Superintendent McGuigan and Lloyd McCaig, your Head of Legal Services, for your input as well. It's a hugely important issue, and one that we will look to see how best the board can support you going forward. And you mentioned earlier on, Chief Constable, about the board's role in terms of resourcing. We have done and will continue to stand beside you in lobbying for greater resources for the PSNI. And we all recognise the importance of dealing with legacy issues, particularly for victims and their families, but we also need to make sure that there is a clear understanding of resourcing implications, and today's discussions and presentations have certainly highlighted that. Turning to current day issues, there are a number of questions which I will come to in a moment, and unfortunately, because of the time, members, there's not going to be much time for too many of them. We'll move them into the private session. Can I first of all wish all of those, before we come to the questions, all of those officers injured following the disorder at the football recently, a very speedy recovery. And can I also join in political condemnation of the disorder in Londonderry during an Easter parade, and the orchestrated, once again, use of young people in that violence. So I'm now going to open with a question regarding the Sean case as it is mentioned in the media. And can you give us a comment on the current update on the Sean case running in the media, which alleges sectarianism in TSG?
Yes, of course. Thank you, Chair. And this issue was raised at the previous policing board, where I explained then, and just to remind you that this came as a result of an article in the Belfast Telegraph, an interview between this officer Sean and a journalist, where issues of sectarianism were raised. And I was asked actually by Alan about the well-being and welfare of those involved. So I've met Sean. That was a private meeting between Sean myself and his solicitor. It was a really positive meeting. He's a decent man, and he was an exemplary police officer. I'm not going to go into details of the meeting, but what I want to assure this board is I am absolutely satisfied that the concerns that you may have had from the article, I have no concerns that the blacks, the officers, his colleagues, acted in a sectarian way towards him. I've also met with the blacks, the team, who were concerned and hurt by what had been said, and actually were very concerned about Sean as an officer and an ex-colleague, who many of them were still very much in touch with and friends. I'm reassured by a number of measures that we've undertaken, not least of which me going to speak to the Inspector Sergeants and all of the team, that there has not been sectarianism towards anybody on that team. In fact, I asked for a show of hands, and I would say between a third and a half of the officers were Catholic officers, and they have a great affection, fondness, and professional admiration for Sean, and they were concerned about his well-being. I will also make comment that I've spoken to retired officers. I want to speak to more of those officers who have left the TSG team, and it's clear that they are extremely upset and hurt by the allegations that were made. Indeed, one of the officers I mentioned at the last board had written to me to explain that he'd met and welcomed Sean to the TSGs, and that he knew that none of these behaviours had occurred because he was a Roman Catholic officer, and I've spoken to that officer. Sean is a thoroughly decent man, and he had an exemplary police career. I cannot explain the article in the newspaper, but I want to assure you, and I'm certainly not a defensive individual, I look wherever there is a challenge to see the merits of it or not. And I know there will have been sectarianism, racism, bigotry in the PSNI because it's everywhere. It exists everywhere in society. It will exist amongst members of, or members that have been on the policing board. And I said to Sean, and it was a really positive meeting, he's a thoroughly decent man, that we're going to do a survey, which Pamela is leading on in the autumn, where if people have got any concerns around any protected characteristics that they may have, in whatever way that may manifest itself, that the survey will see how confident they are in the organisation, whether they've had any issues in the organisation, and that will be shared with this board. So any learning around behaviours in the organisation that we need to address, or any issues that we need to address, we will. Okay, there is no, I think I mentioned previously, there was a review of the allegations made at the time. Sean was offered an independent chief inspector to examine the issues and investigate, which he decided that didn't need to happen. And there is no legal case or ongoing investigation. And I'm hoping that we can draw a line under that particular episode.
Thank you. Jerry, do you have a supplementary on this?
It's just very quickly, because you mentioned the survey. Is the survey going to be anonymous?
Yes, Jerry, it will be anonymous. So the way I've done it, there's going to be a national survey of police forces. The Home Office have commissioned a piece of work with Leapwise, a consultancy. We wouldn't ordinarily necessarily be part of that, but I've asked to be part of it. So we're going to do a bit of a hybrid. We'll be part of the national survey so we can benchmark. But because the PSNI has a unique and bespoke operating environment, different challenges, I want a bespoke set of questions to get beneath the surface around any cultural issues. And those questions, by the way, will be framed, and Pamela's, as I say, leading on this with Claire Duffield, with consultation with those support networks. So the support networks who would represent members, or diverse members of the community in the PSNI, they will help us frame those questions. And again, to reassure you, and this is on the candor point, that survey will be shared, the results of that survey will be shared with the board. I don't know if Pamela wants to mention anything on that.
Just a little bit. I think we are planning to probably bring more detail of this through to Resource Dairy, but we had undertaken the survey last year with Inspiring Change. One of the key recommendations was a deep dive in and around the area of inclusion, because I know there had been questions raised around gender, sectarianism and so forth. So we will do those deep dive sort of workshops with the workforce, as the Chief has said, in consultation with our support associations in the structure and the development of that as to what it will look like. But we're going to develop also a suite of questions throughout the year, sort of pulse surveys that go through the year, picking up on the work that Leapwise have been commissioned to undertake nationally, so that will start to give us benchmark information as well. But we had quite a thorough survey last year, and we do also later this year want to get a sense of how we progressed with that. So I suppose it's a little bit of all of the above, but that sort of regular pulse mechanism lets us not overly overload the organisation, but be able to see progress as we go through the year.
Can I just on that 1 mention, only because when I went to see the Blacks team, there are a number of things they've dealt with recently, really difficult stuff, and they've done it really, really professionally. And members of the public had commented to me on the team with that regard as well. So I should mention that. Thank you.
Thank you. And just to clarify for those online, when we talk about Blacks, we're talking about TSG.
My apology. It's my apologies. That's the way they're defined as colours on the teams. Yeah.
Okay. Thank you. Very quickly.
Yes, Chief Constable, in your meeting with Sean, has Sean disassociated himself from the newspaper article, or is he still standing over it?
So I'll say again, the meeting was in private. It's a private meeting. I'm not going to discuss it any further than I already have in public. And I'm going to draw a line under it.
Okay, thank you. Unfortunately, that's all we've got time for today. So could I thank you, Chief Constable, for your openness in all of today's discussions, and indeed all of your team who are here today, and you, Sir Ian, for your input today. Could I thank everybody who watched our meeting online today, despite the very good weather. You've still been here. Thank you. Our next meeting is on